All right, we are back on Morning Line. It's our final segment this morning with Clint Kelly, malpractice attorney. If you'd like to jump in, we have some lines open. 737-7587 is the number. You know, it can be intimidating for anyone dealing with a medical crisis, an issue. You know, your health, that's on your mind. And then you think, maybe, okay, I've been wronged. Do I contact an attorney? Gosh, how am I going to afford an attorney? Can you kind of just walk people just through the basics if they think they need one, what it will cost them, and how to go about doing that?
All right, well, first things first, it will cost them nothing.
Okay.
All right. The consultation is free. The representation is free. The only time the patient pays is if I collect money for the patient, either through a settlement or a verdict. And
is there a percentage on that?
Yes, it's 1/3 by statute.
1/3 by statute.
Secondly, if a patient or a family member suspects that something's gone wrong, and again, you got this, everybody has this instinct, this gut feeling something's not right, pick up the phone and call. It costs you nothing to call and get an opinion. And I have a paralegal named Pat at my office who does the intakes, and she's pretty good about asking exactly the right questions, and we review every intake. Now, there's some cases, Nick, and just you look at them that you say, this isn't going to fly. But far better to do that than this situation here with Pamela, where someone has perhaps sat on their rights, the years passed, and then they think, you know, I think something went wrong here, or the patient didn't get any better, got worse, even though the doctor was telling them they get better. They call, and I tell them, I'm sorry you waited too late. So just simply pick up the phone and call, and we'll always give you an opinion, and it's free.
I'm curious, if you have 10 cases that you've handled, in general, every 10 cases that comes along, how many of them actually go to trial, and how many of them are settled percentage-wise in your mind?
Now, when you say case, you mean calls, or you mean cases we actually
No, not
take?
calls. Let's say you've got active cases. You take on active cases and good cases, and you're in negotiations with the hospital or their lawyers. How often, is it more often settled, or do you end up getting trial more often?
It's probably, I'm going to say 60-40, 60 settle, 40% go to trial.
Okay, that's what I would think.
The majority do settle, but that's because I try to take cases that are winnable.
Yeah.
If you have to take the best cases. If you don't, you'll go broke trying them, because doctors win 3 or 4 out of every 5 cases you try.
So most of the time when it goes to trial, is it either, and I'm just curious, is it either because the hospital just said, you know what, we're going to fight you on this, or is it because your client is not satisfied with the offer?
It can be both. It can be a situation where there's simple defiance, you know, on the part of one party or the other. Mediation has changed. It's been a game changer in terms of getting the defendant and the plaintiff, or the patient and the doctor, or a patient and the hospital together to try to come to some resolution, because the law does favor settlements. Occasionally there are situations where we can't agree on the dollars. We think the patient's injured too badly and deserves more money. The hospital thinks they shouldn't pay as much money. Or there may be a situation where a doctor just simply says, I'm not going to consent to a settlement. And in Tennessee, a lot of the doctors are insured by the same company, where they can basically veto a settlement.
Okay.
They said, look, I didn't do anything wrong. I'm not going to settle, even when they have done something wrong. Or another case, they hadn't done anything wrong, and they're proven right by a jury. And I can't emphasize enough, juries find for the doctors and the hospitals the vast majority of the time. That's why we have to be very picky in the cases we take.
Interesting that that's the case, because jurors are all prospective patients themselves. I wouldn't think it would be one way or the other, it'd be 50-50.
You just hit the nail on the head.
Yeah.
Jurors are patients.
Well, I try to put myself, then, I would think, if I'm a juror and never had, in the shoes of the person who got messed up.
They got to go back and see the doctor. They got to go back to a hospital and get health care. And I think there is a natural tendency to respect the medical profession.
Yes.
Which is they've earned that respect. But also the fact that at the end of the day, jurors still need the medical system. So I think it's harder for them to find for a patient when they are consumers of the same system.
Okay, then that leads me to my next question. When you talk about hospitals and the jurors, you know, having a respect for the hospital, and because of that, I mean, it's just, I just can't help but think that you would put yourself in the shoes of the victim more than the hospital, fearing that next time you go. Is it fair? I guess this is my point. Is it fair, and it's out there, and we've seen a lot of tort reform that has placed caps on how much money you can get in cases you win. Is it fair to say that we need that tort reform, because every time Clint Kelly wins and gets $1 million settlement for one of his clients, I'm paying more at the doctor's office?
Well, that's what I'm saying is that the doctors and the hospitals are winning the vast majority of these cases.
I know,
so
but I mean, I know what the reality is.
It's like prescribing a cure for...
But the perception is, Clint, you and your money-grubbing clients, I'm sorry he got burnt with a little bit of scrub there. He's going to get $1 million, and next time I go to the hospital, I'm going to have to pay a lot more in my copay because these doctors have to pay more for malpractice insurance. That's one, and I'm playing devil's advocate here.
Yeah.
You know what I'm saying?
Yeah, and it's false. I'm just telling you straight up, it's false. And what's even worse about it is the fact that the person that says that is the same person that will call me 2 months later and say he got injured in the hospital. He wants full compensation. Right. Okay? It's always somebody else's problem until it happens to them.
Yeah.
And that's the way, unfortunately, I think juries look at a lot of these cases. It's hard for them to relate to the patient because they say, that'll never happen to me. I've got a good doctor. I go to a good hospital. I've got supportive family members. And so it's hard for them to relate to somebody. It's the old saying, bad things happen to good people. And my response to that is, bad doctoring can hurt good people. And it just depends on the situation. But you don't need tort reform. You don't need a cure for a disease that doesn't exist. And in this case, in Tennessee, we just don't have many multi-million-dollar medical malpractice verdicts. You can count them on one hand.
No, you don't. You don't see it. Now, is malpractice, I don't know, maybe this is a question I should ask a doctor, but is malpractice insurance, because when they lose, they have insurance. It's not the hospital paying, it's the insurance company that is. Is malpractice insurance these days very, very expensive?
Yes.
Okay, it is. So, and I understand there were some doctors who said, I'm done with this business because the malpractice is too darn expensive. Every time I turn around, someone's trying to sue me for something. And you know as well as I do, anyone can sue for anything, whether they have a case. Now, not you, because you don't take them on unless they've got a legit case. But that can happen.
Remember what I said, Nick, you can have 5% of the doctors making life miserable for the other 95%.
Okay.
5% of the doctors can be committing the vast majority of the malpractice and make the other good 95% have to pay for their mistakes. And that's just not in medicine, that's in law, that's in a lot of different professions. It's always that small minority that makes the rest of the bunch have to pay.
And what's interesting, what you say about that small minority, a doctor losing a malpractice case is not losing his license to practice medicine. Now, it may be written up, but you say oftentimes these doctors that get busted or lose these cases just leave the state and start afresh someplace else.
He may lose the case. His insurance company pays the judgment or the settlement, and that's the end of it. These guys aren't being put out of business. These guys aren't losing their right to practice or having their employment affected. Their insurance company, which all of them have, is paying for the judgment, paying for the mistake, if you will.
And in most cases, if they reach a settlement, part of the deal is you take it and you go quiet.
That's correct. Most physicians will require a confidentiality agreement.
Except for a very recent high-profile case you were telling me about.
That's right.
The one that, again, would you mind recapping? Just remind folks of that and what was unusual about the outcome on that. Listen to this, folks.
That was a case in Kentucky where an anesthesiologist was participating in a colonoscopy, and the patient left the cell phone on in his pants.
By accident.
By accident. And this anesthesiologist began to make fun of the patient during the procedure, basically alleging that the patient had a sexually transmitted disease and, calling the patient a whiner and a baby and all kinds of things like that. And this was caught on the cell phone. But what made it doubly worse is one of the assistants during the procedure thought the anesthesiologist was telling the truth about the patient having a sexually transmitted disease, and it got written into his chart. And so he goes home and he hears this, irate as anyone can understand, and then to find out that sexually transmitted disease was in his medical records, which was false. So he sued the doctor for defamation and medical malpractice and got a $500,000 settlement, and the actual settlement itself and the terms of it were published. And that's exceedingly rare.
It was published. Now here's the thing, I sympathize with this guy, and I would be awful, and I would hate to have had that happen to me. But $500,000, and I asked you this before, and I guess I'm unclear again on remembering the answer. What was the damage here? The damages. Whatever the procedure was successful. They did it. Yeah, they did it while they were bad-mouthing the poor guy. And, in his medical file, I would think, okay, yeah, that's certainly wrong, but that can just be corrected. It's not like that went public.
Now, wait, you just said something that you're taking for granted, which is, quote, it can be corrected.
Well, it's my medical file. It's not true. Erase it. Get it out of there.
They don't erase medical records.
Well, it's mine. They have I can tell them exactly what to do with it.
You can't erase a medical record. You can make a change to it. You can edit it, but you can't erase it. it's once, I don't know if you ever seen that Seinfeld episode where Elaine keeps going from doctor to doctor to doctor, and they all write that she's a problem patient, and so she goes to a new doctor hoping that other doctor won't get her prior medical records. It's the same thing.
So it's kind of going to be in there, but I mean, I just think that could be addressed. But it was the big, and like I said,
and I
understand he was wrong, but what was the $500,000 worth of damage here?
Because he was humiliated.
But it wasn't public. He was unconscious. They were talking amongst themselves.
It's public because the people in the hospital thought that he had a sexually transmitted disease. Well, I mean, I don't know, Nick. If somebody writes in the hospital and says you got herpes and it gets all over the place,
I guess,
the people in the hospital
did it get all over, or was it outside the hospital?
It was in the hospital, and like I said, it was in his chart, and nobody wants to be written about themselves as having herpes.
I understand, and then from there, you never know where it could get out beyond that. But then the key point that we wanted to make was that settlement that came down, part of it, and maybe this guy insisted on it, was that, well, you know, I'll take the settlement, but on top of it, this has to be out there.
I think there was also the fact that he knew and the lawyers knew that jurors would get very mad over this case, and that's the thing.
Meaning that they had him over the barrel. You have no choice. You do what we say, or we're going to trial, and you're going to get wiped out.
You ever get jurors mad? Katie, bar the door.
Yeah. Think he could have gotten more money if he had gone to jury trial? He didn't have to accept that settlement.
I don't know, because I don't know enough about this guy's problems, and I don't even know what the sexually transmitted disease was, but I'm just saying, to have that published like that tells me that, as you said, he had him over a barrel, and he wanted people to know this happened. And by the way, that doctor left Kentucky to go practice somewhere else.
Good to know he's practicing somewhere else, huh? How about that? Hopefully it's not Tennessee.
It was a she.
Hopefully she's not in Tennessee. Hey, Clint, thank you. As always, a fun conversation, educational. And we're going to put up your phone number right now as well. We'll give it once more after the break. But there it is. If you want to make the call, Pamela and others, doesn't cost you anything to make the call. You can find out if there's the consultation there if you have a case. 824-3703. 615-824-3703 is right there in Hendersonville. We'll be right back after this. Thanks, Clint.
You know, I wonder, in